Representative Senator Handler for their leadership in this issue. I also want to call out the work of the staff, Rebecca Miller and Matt Hackman. They've been kindred spirits in this work, reading the same research, interviewing the same experts, and it's gratifying and reassuring that their work and conclusions and those of the trial court's pretrial task force so closely aligned. In terms of the specific elements of the bill, we applaud the expanded use of probation's community correction centers to include pretrial cases allowed under Mass General Law 211F. We proposed this exact change under separate legislation, House Bill 1846, filed by Representative Christopher Markey. The bill would accomplish opening up access to the community centers as a resource for pretrial purposes. House 1584, Senate 802, includes probation, working with the Department of Correction and the various sheriffs to allow for pretrial sentence population and sentence population step-downs. We've begun the work on the sentence step-downs very specifically with a number of sheriffs, the sheriffs that were here today, Sheriff Compton, also Sheriff Cousins in Essex, and Sheriff Ash in Hamden. 1584 and 802 calls for the use in short, we've developed the pathways for this work on the sentence side. This bill would allow us to authorize us to adapt those very pathways for the pretrial population also. House 1584, Senate 802 calls for the use of an empirical risk assessment tool to be completed to aid in judicial decision-making in the area of pretrial. The pretrial task force is actively pursuing the development of a Massachusetts-specific failure risk tool as we speak. The pretrial task force is in active discussion with a number of national authorities on this, the Arnold Foundation, UMass Medical, Lawrence Psychiatry Department. They developed the risk tool that we're actually in the process of implementing on the juvenile side. We're also having conversations with the University of Cincinnati. They're the developer of the validated risk need assessment tool, suite of tools that we use to guide probation supervision. We're talking to the Crime and Justice Institute here in Boston that does a lot of this work nationally, and also with the Pretrial Institute in Washington, D.C. We welcome the support, and we hope the commitment and financial backing required to do the development of this work at the highest level, from tool development through implementation and also through fidelity monitoring. Getting this right, implementing it correctly, is the heart of this work. Finally, and I know I haven't covered every aspect of the legislation, but it's the Pretrial Services Division. As the alternative to incarceration in the criminal justice system, probation fully embraces this aspect of the legislation. It's precisely the work that we're designed to do. Today in Massachusetts, the Probation Service has some 12,000 individuals, adults and juveniles, under pretrial probation or pretrial conditional release. We manage about 40,000 different individuals in this status each year. A good portion of those individuals are on that status as either a diversionary pathway or an immediate need for intervention as identified by the judge at arraignment. We see this most specifically in many of the neediest pretrial defendants, individuals who present in crisis. They present as homeless, suffering from mental illness or alcohol and drug, most often heroin these days, dependent. We can do this work far more effectively through the affirmative, data-driven design, development, resourcing, and implementation of pretrial services envisioned in this bill. I have no doubt that the comprehensive approach outlined in the bill with the commensurate resources would result in Massachusetts not only joining many of the most progressive jurisdictions in this country in this approach, but we believe it would also result in a fairer, more consistent, evidence-based approach to placing the right person in the right place for the right reasons. It would go a long way in reducing racial, ethnic, and socioeconomic disparities and improve the outcomes for those individuals before the courts. Also, I just want to add that as you consider the testimony from Chief Justice Gantz in regard to reform of mandatory minimums, sentencing for drug offenses, please know that while incarceration is still the primary response for drug crime, probation is prepared to continue in both its role as an alternative to incarceration pretrial as well as post-incarceration where appropriate. We stand ready to employ evidence-based supervision principles to hold probation accountable, protect the public, to provide support, and reduce the likelihood of recidivism. Our work with the Pew Center of States indicates that evidence-based supervision practices, informed by a validated risk need assessment, intensive supervision of high-risk offenders, such as we do under the Hope More model, as well as the drug and other specialty courts, can reduce crime by 20 to 40% compared to other sentencing options for those at the highest risk and need levels. I'll conclude with saying the key to all of these options is a high-functioning, adequately resourced probation service that can devote the necessary time and attention to people to ensure treatment and service goals are being met, to hold probationers accountable. And the Massachusetts Probation Service stands ready to do this work. Thank you for the opportunity to appear before you today on behalf of House 1584 and Senate 802.
Thank you, Commissioner. Any questions?
Thank you, Mr. Chairman. Thank you for all you do, Commissioner, for all the leadership of those issues. We do have a couple questions. I hope you can help me understand how this is the bill decisions are likely to really change. I'm not questioning the bill, but just to understand. We're going to have a risky instrument, which you know I support, we're going to try to get that going. So that, we have been working together, Commissioner, to get funding in place to support the development of a risk need instrument. So that's something that clearly makes sense to inform decision making and have judges have the best possible batting average using the best available tools. Talk about how this will, if it will, reduce the number of people held on short cash bail, or will it?
So I think what you'll get is more consistency of decisions. I think you'll get a more focused discussion in the court about sorting people on an empirical basis into low risk, not to fail to appear, high risk to failure to appear, and then a group in the middle that I think would require some level of pretrial services. And so I think beginning the analysis, beginning the presentation in the court, allows you to begin from an informed perspective. So if this individual is in the lowest risk for failure to appear, what is it about this guy, Mr. Prosecutor? Or if he's in the highest risk, what is it about this guy, Mr. Defense Attorney, that separates him out? What are the very specific factors? So I'm really talking about the exceptions, and I'm not really, this isn't sort of a full-on discussion of all the various aspects. I know that this guy belongs to a class of people that has a high or low likelihood to fail to appear for trial. What is it about this guy? It becomes a much more targeted and focused discussion. When we met with the Arnold Foundation, they amassed a massive database, 1.5 million cases across 18 states, including the federal government as well. And they developed a risk scale for offenders for a likelihood to appear and likelihood to reoffend. And what they found was that nationally, about 50% of the very lowest risk folks are held pre-trial. And then what they found was
Lowest risk to reoffend or lowest risk to?
for both, failure to appear and to reoffend. And then they looked at the highest 8%, the folks with the very highest risk for failure to appear, very highest risk for reoffending. And what they found was that only half of those were held. And so the conclusion is that it's really about, it isn't about being soft on crime, it isn't about being hard on crime, it's about getting it right. And that we really want to, release some recognizance or very low bail or very light kinds of controls, and from a pretrial services perspective, those folks who need it. Because the other outcome of their research was getting it wrong and putting the wrong people in jail actually increases their recidivism. So the whole focus is on getting it right, because there are costs at both ends of the scale for the high risk and the low risk.
So I guess, so the statement is not necessarily that we're going to hold fewer people, but we're going to hold the right people?
I think that's the goal. I think what you see now is a fair amount, the data that we have available to us shows a fair amount of variability. And I think you're going to hear testimony that there are instances where folks that are being held perhaps didn't need to be held. And similarly, I think for folks, I mentioned we have 12,000 folks per day that are in some kind of pretrial status with probation. I think getting those, in some ways we're creating liability for those people. And I think getting the right level of conditions and the right levels of control reduce the likelihood that they're going to fail pre-trial, while not increasing the likelihood that they're going to show up for trial.
Commissioner, we had some testimony earlier from the sheriffs about the percentages of folks that are held on pre-trial being under $1,000. You were here for that testimony.
Yep.
And those being held on over $100,000, those being held without bail. I just mentioned to the senator that there was this sort of thought running through my head that we're talking on the one hand with minimum mandatories giving judges more discretion to make choices, and we're talking about judges making choices that we're not happy with when they set bail for $1,000 or greater, or some number between 1,000 and 100 or whatever that they likely know is going to result in the individual being held as opposed to released. Does that seem at all contradictory to you?
So my view of the system, I've been the Commissioner of Probation for 2 years, so I've had a perspective on the system that I feel as though we do a disservice to the judges. I think oftentimes the dynamic that takes place is a prosecutor and a defense attorney meet in a hallway, come up with a plea, and go into court, and because of the press of business, rather than have a judge sort of relitigate this entire affair, it's you agree on a plea, fine. And that those will be the pretrial conditions that we do. We'll put him on GPS. We'll give him drug testing. We'll give him, and I think in some, and or it will result in a $1,000 bail, which the guy can't come up with, and then he's held. I think resetting that process and resetting it and informing it by a validated risk instrument that does that sort of pre-sort, that gives guidelines both to the prosecutor and the defense attorney coming in the door, I think really organizes that process better so that you get better decision making and clearer decision making from judges.
Do you get legislation for that?
Well, I mean, we're working on a pre-trial instrument as we speak. So I think you're seeing it embraced by the trial court. I think funding is an issue. We did this work on the juvenile side, and we're actually trying to implement a validated risk tool on the juvenile side, and that's taken us 4 years through grants and various processes to do that work. And I think the value of the legislation is consistency across the system.
Any other questions? I'm going to ask, because the public has been very patient, Representative Smith, I'm going to ask you if you would hold. We have a couple of panels that I know need to be out of here in about 15 minutes. If you can hold for that period of time, unless you're going to be really brief. All right, we'll have you down. Senator John, we did go through...
and I don't have to. I do understand.